Ms. Dealer, case has been drawn to our attention, which was decided in June of last year, called Poole Borough Council against GN. Had you intended to refer to that?
No, my lord.
No. Well, we have copies of it. It may be that you can't assimilate it while you're on your feet, in which case we may ask for written submissions on it.
Yes, certainly. Is this something that's just come up over the...
Short adjournment, in the way that these things do. No, but I don't know that we have copies to hand.
Just of the head note.
Yeah, it's just off the head note, I think. It'll give you something to work on. Right, but don't worry about it now.
I think probably the safest, my lord, if I simply say that I will read it, and then it may be that my own friend and I need to put in something short,
yes,
by way of additional written submissions.
Very well. Thank you.
Yes, it looks very much like a sort of on the line of Stovin and Wise and the sort of cases we were referred to this morning.
Then,
but I don't look at it now, but it did strike me. It didn't seem to be raising anything very new.
I remember reading it at the time, but I have to say I don't retain sufficient recollection of.
No, never mind.
Assumed responsibility. Right. I'll look at the full judgment again afterwards, my lord. Shortly before lunch, I had just reached the point of bringing to your lordship's attention, the provision in the AASP for the provision of additional security if there was a threat. There is, however, in my submission, nothing that supports the idea as a general rule, and of course there was nothing that suggested that either Spirit Airlines was under a specific threat or that it wasn't under a specific threat when Mr. Butler was talking about them, that operators could provide their own private security. But what that section of Mr. Butler's evidence does in my submission reinforce is that security, who and what and when, was entirely an area that was under the authorities' control, under their bailiwick. They were the ones that decided if there could be any further security. They were the ones that decided when. They were the ones that decided after consultation if there was a threat that meant that they ought to be providing something extra. And that, in my submission, is important to this appeal because it underpins the existence and the scope of the duty of care, because the duty of care included the control of the airside where the aircraft was parked at night. And Mr. Justice Adderley had all of the evidence, including, of course, the witness evidence, which had been witness statements, the accuracy of which Mr. Roll had confirmed at the outset of his oral evidence, and on which, as I've already said, he wasn't cross-examined. And he had, to the limited extent that there was, the evidence from Mr. Ferguson and from Mr. Butler. And in my submission, there was no reason for him not, implicitly, of course, because I accept that in his judgment he doesn't expressly say, well, I accept what Mr. Roll says in his witness statement, but there was no reason for him not to accept that, because there wasn't, in fact, any outright inconsistency between what Mr. Roll was saying and the limited information that came from Mr. Ferguson and from Mr. Butler. So it wasn't one of those questions of the judge having to decide one person's evidence over another. Now, the appellant, of course, appealed on the basis that this was wrong. And the way that the Court of Appeal, and of course, one can always look at judgments, obviously with the exception of this committee, and say, well, that could have been better expressed, or we could have addressed it slightly more completely. And I'm not suggesting that the approach of the Court of Appeal was in every respect perfect. But what they did do was they set out the law as it relates to overturning facts which have been reached by a trial judge on appeal. And they evidently disagreed with the submissions that were being made, at least in writing, because they don't seem to have made any submissions orally, by the authority to say that the trial judge had been wrong. So what they very clearly had in mind in my submission, and this is set out at pages 88 and 89, is the responsibility on them not to effectively take their own view of the evidence, but to accord to the trial judge sufficient respect for the conclusions that he had reached. Now, those three things are, we say, the conclusions that really the appellant needs to overturn in order to get going with this appeal. And they're not inferences, they're not evaluations, they are conclusions that the trial judge reached that were entirely open to him to reach. The thief wasn't known. There was no prospect then or now of establishing that it was Mr. Terreros or indeed anyone else in particular. There was no prospect of establishing then or now that the thief was authorised to be airside at 1 o'clock in the morning. The appellant had absolute control over the airside in April 2007. Who got in, how they got in, whether they got in at all, and that operators such as the Respondent were dependent on the appellant's control of access to their side to prevent those who weren't authorised to be there from getting onto the apron where the aircraft were parked overnight. And the way that I put it...
Well, your client gives Mr. Terreros and the other pilots and mechanics a pass.
I'm sorry, I didn't...
Your client gives them a pass. It's employees, it's pilots, it's mechanics. It doesn't just give them a pass for the day, it gives them a pass for them to keep throughout, knowing perfectly well that with that pass, they are allowed to cross over airside at any time of the day or night.
Absolutely not, my lord. What the evidence was, and I will take bits, is it's not an access all areas at all times permission, because airside is a restricted area. And what Mr. Roll, if I take you through, firstly, what Mr. Roll put in his witness statement, he emphasised that you had to be escorted and screened. This is 279 at paragraph 9.
Yes?
And it starts at 278. Penultimate line 278, hard copy at least. This area is restricted from unauthorised personnel. Only persons with an AA identification designated for that area, and it's set out in the AASP, the different colours for the different areas that you can't get everywhere with one pass, are allowed in that area. Passengers going to aircraft should always be escorted by the airline agent, only after the passenger and agent have been screened. Also, all crew must go through the same screening process for each and every flight, or every time they leave the secure area and want to re-enter. The defendant's security and its contractors are solely responsible for the security of everything on the airside. Then Mr. Seifert was called to give oral evidence. And this is at page 877. Starting on 876. And he's being cross-examined. When your pilots or employees are off duty, line 15, what do they do with their security badges? Well, of course, they don't hand them in, they keep them. And Sir Cyril Fountain says whether they are on duty or not on duty, they would be able to, how should we say, legitimately get onto the airside. And then answer, yes, I just wanted to say, may I say just one thing? It would have been normal protocol if we had any flights. There is normal protocol in place that any flights after, I think, 9 o'clock in the evening and 5 o'clock in the morning, if we had any flights during that period of time, we would have to inform security supervisor at the main airport security desk of any aircraft movement. Sometimes we get late charters and they'd be there because they lock the gates in the main terminal. And then I think, nevertheless, whether there's a flight, a charter or not, if the employees had the means of legitimately going to the airside, yes. And then Tamara Winder Sears, who was the authority security guard, was being asked about this. And this is 907. She's been asked effectively about the procedures. Line 19, they approach you from the roadside, speak you, I imagine. Answer, yes, we check the badge, and based on who you are, you must meet certain criteria for that particular time. We check you, we pat down, check bags, also your ID badge based on which area you're supposed to be going to work. We check all that. And the question, once I've presented myself and I'm cleared and through, I have general access, not just anybody. I mean, once I've cleared, I'd have general access. And then she says, once you're cleared and your ID, I think that should be badge rather than damage, states you're able to go into that particular area. And then this is where she goes on to say the passage that I brought to your Lordship's attention earlier. At that time of the incident, there's only one particular group of persons that would access that gate who we would allow to access that gate, Bahamas mechanics. And then she says at line 20, they are the only ones who we allowed because they are ongoing around the clock through the night. So, no, my lord, it's not a question of I have a badge, I can go to the airside any time, day or night that I want. That would be insufficient controls. You get granted your badge, which gives you a certain colour, depending on what your role is and the areas of the airport that you're allowed to access. But even so, every time you're trying to come through the gulfs in order to access the apron, the airside, then what the security guards are doing is they are checking you against the flight that you say that you're there for, because it's not just a question of, well, here's my badge, I can get through and access whatever I want. So the way that the system is set up by the authority is precisely the point that my Lady Arden raised at the beginning. Well, no, it's not a question of I've got a flight at midnight and I can access the area from about 2 o'clock, or at least it shouldn't be. That your access should be controlled by reference to the reason why you are there. Now, what we know, of course, from Miss Winder Sears is that the only people who were authorised to be in that area at that time were the Bahamas mechanics. So it wouldn't, we say, matter. Even if one could point the finger at Mr. Terreros, he still wasn't authorised to be there at that time. There was no Western Air flight that was leaving. He wasn't on the roster. He hadn't been on the roster for 4 days prior. He should not have been allowed to access airside because he had no legitimate reason to be there. So it's not, it is slightly more nuanced than, well, you know, have badge, can access. The system that the airport puts in, or the authority puts in place, is intended to provide this extra layer of protection that you have to have a reason for being where you want to be at the time that you want to be there.
I think it was touched on this morning. There is a possibility that, of course, he went to the plane or near the plane at a much earlier hour than the time when the plane was stolen. But anyway.
But probably not 4 days prior.
Probably not. Not 4 days, no.
And the aircraft, of course, had been parked there. I think the evidence says at about 6 o'clock, 6:30 that evening.
I think so.
But Mr. Terreros had not been flying for 4 days before. So yes, there is the possibility, of course, that if it was him, and this isn't the time or the place to be pointing fingers perhaps, but if it was him, that he would have accessed somehow at an earlier stage than 1 o'clock in the morning. But that is a point I made this morning. That's information that ought to have been solely within the authorities' knowledge, because they are the ones that have the obligation to log everybody who is going airside, and not just log everyone who's going airside, but log everyone that tries to go airside and gets turned away.
Okay, thank you.
Yes, so saying that the operators, such as the respondent, were entirely dependent on the control that the authority has, because I think the way that I put it this morning was they were the first and the last line of defence beyond the relatively limited security that is provided by the manufacturers of the aircraft themselves. the control, the protection, is all about who gets to airside. And it's something of going off down something of a wrong route in the submission if we're looking at this on the basis of responsibility on the airport to guard the planes. It's not in my submission about that. The responsibility is to guard the access to the airside. Now, if I can turn to the law, and again I'm grateful to my own friend for having been through it so fully, the first question is whether there is a private law cause of action. And this isn't, in my submission, a case that is centring on a public law duty which is owed to the general public, of which the respondent is just one member. And nor was it a case that was based on a failure on the part, or alleged failure on the part of the appellant, to exercise its statutory powers or even any of its statutory duties. It was a claim that was based on a private law relationship created over several years, 7 years, on the back of the appellant having a wider responsibility to the general public because it was the airport authority. The complaint is not that the authority failed to act. The complaint is that in acting, in the way that it carried out its control of the restricted airside, it did so negligently. It's straightforward common law negligence, and it is dependent in my submission on the same principles. Now, I hope that what I'm about to submit wasn't entirely superseded by your lordships last year. But turning first of all to Staven and Wise, at page 1356, it's at tab 13 of the authorities. We have Lord Hoffman at G, negligent conduct in the exercise of statutory powers. And since Mersey Docks and Harbour Board trustee in Gibbs, it's been clear law that in the absence of express statutory authority, a public body in principle liable for torts in the same way as a private person, but its statutory powers or duties may restrict liability. And Lord Hoffman goes and he makes reference to X and Dorset Yacht, and he says, in the case of positive acts, therefore, the liability of a public authority in tort is in principle the same as that of a private person, but it may be restricted by its statutory powers and duties. In the case of positive acts, and that is, in my submission, that's exactly the scenario that we're in here. We're not in a case of omissions. We're in a case of the authority having engaged, having made the decision. It didn't have a choice whether there was to be a system of security, but it did have absolute control over what that system was going to be, and that system included the controlling of the access by means of logs and people and CCTVs and ramp patrols and so on and so forth. And that's where the failure is said to be, not that they didn't do something extra. And then Lord Hoffman came back to that point in Gorringe, and this is at page 1222, which is at tab 8 of the authorities. He's highlighting at paragraph 38 that Gorringe, and I would say in distinction to the scenario that we have here, is concerned only with an attempt to impose upon a local authority a common law duty to act based solely on the existence of a broad public law duty. We are not concerned with cases in which public authorities have actually done acts or entered into relationships or undertaken responsibilities which give rise to a common law duty of care. That is exactly the situation that we are in here. There is the way Lord Nichols put it in Staven and Wise, that there is no hard and fast boundary lines, the references at 1348. He makes the interesting that a power to control air safety may be one of those cases that is more susceptible to there being a concurrent common law duty. But he's reiterating that there is no hard or fast boundary. But what you are meant to be doing is seeing, in cases, whether the statute, whether the authority, whether the statutory power excludes there being a duty of care. And in this situation, the appellant did actually do something and did enter into an actual relationship with the individual respondent. The respondent was not parking its planes on the apron merely as a member of the public. This is a confined area, paying for the privilege to an extent. And the appellant is the one that has set up the security and set up the access control system. And the background was that it had to do something, but it was the one that decided what and how and when. And the access... You
say that setting up the access to the airside system is tantamount to assuming responsibility, as it is discussed in Gorge.
Well, it can be, and it's certainly, in my submission in this case, it is in circumstances where, based on what the trial judge has found, they are the only ones that can provide any security, because the individual operators have understood over the years through their conversations that they are not allowed to provide their own private security. So what the authority has done is it has gone further than just setting up an access control system for the wider benefit of the general public. It has gone beyond that, and it has said, as far as you, individual commercial operators, are concerned, you have to rely on us because you can't do anything yourself. So it is one step beyond merely carrying out that which they have to do because they've been set up as the airport authority.
So that's, on your case, that's not only an assumption of liability, but also it's the bricks and mortar of the proximate relationship with the respondent.
Absolutely, which was exactly what Mr. Justice Adderley said. He was relying on the fact that the operators couldn't provide their own security as the basis for saying, well, there's sufficient proximity. Because it's making that relationship that much tighter.
Even if they could have requested permission to set up their own security, would you not argue in any event that, as it happened, because the authority set up this system, that was the assumption of responsibility, because it provided it to the respondent, that created the sufficiently proximate relationship, and that proximate relationship is not destroyed by the circumstance that the respondent could have done something which it chose not to do?
If the operators were all aware that they were allowed to provide their own private security force to stand at the doors of their aircraft overnight when nobody should have been allowed to be on the apron at all, then I could see that I could have rather more difficulty.
Yes, but of course the evidence doesn't go that far. The extent that it goes to, as far as I can see, is that if a request had been made, an attempt would have been made to facilitate the granting of that request. And that's rather different from saying they would all be entitled to enlist their own private security or provide their own private security.
Well, it doesn't go It's not that easy, we say, for the appellant, because what Mr. Ferguson is saying in 2012, he can't go any further back than 2008. And
It may not appear so, Ms. Deal, but I think I'm trying to make a point in your favour.
I will always take the points in my favour, my lord. I will put that down to improper understanding.
Well, that's my fault, I'm sure.
It underlines the situation of the private security, or the lack of the private security, underlines why, and we're not trying to set any precedent for whatever the airport authority might do with all of the many other operators that use the airport. We have no interest in that. But it underlines why, as far as Western Air is concerned, there was a sufficiently proximate relationship at the time of the theft.
The thing I find very odd about all this, it may not matter, is there clearly was a proximate relationship because there was obviously a contractual relationship under all this. I mean, they were paying for a service, and presumably there was some sort of contract which defined what they were paying, and one would have thought it to define what the terms of that relationship were.
Well,
and yet
all there was an oral arrangement. Mr. Roll says that it was just an oral arrangement, the contract.
Does he say that?
Sorry?
He says that somewhere, doesn't he?
Yes, it's in his witness statement. He says it was a pursuant to an oral arrangement.
And how are the fees fixed then? Is that simply just done? You know, it may not matter because this has been done. I mean, the fact that there's a contract doesn't exclude a duty of care. But
279 at paragraph 10, he says, since going into operations at the airport prior to 2000, the plaintiff entered into oral arrangement with the defendant for the use and lease of office and desk space, landing fees, aircraft parking fees, screening. The said aircraft was covered. The plaintiff's company prepared and submitted monthly invoices to the defendant, having determined its scheduled flights and landings from information provided by air traffic control.
But anyway, even if it was oral, it's clearly a contractual arrangement, an enforceable contract, I assume.
Yes, but one can see perhaps why it wasn't felt that there was sufficient to put the case on a contractual basis if in fact it was only an oral arrangement. And it does seem to have been at that stage at any rate, I mean a lot of these documentations were after the event, something more of an informal arrangement.
Yeah, well, whatever it was, I mean, these cases like Stoven and Wise and Gorringe, there isn't anything comparable to that. And one's looking for arrangement, but here, which supports a case. But here, you clearly have a proximate relationship, whether it's called contractual or not, because as described there. So why is that not good enough for your purposes?
Well, we're perfectly happy to say it is good enough. But in terms of what the trial judge was saying, to the extent that I have to uphold that, then he is relying not on the contract, but he's relying on the fact that there was a little something extra, if you like.
Yes, I think my Lord's point is this. He's not suggesting that there was an enforceable contract in that you could plead various implied terms of which the appellant wasn't breached, but the existence of this arrangement between the parties is indicative of the sufficient proximity of relationship.
Yes. It's beefed up, I'm sorry that's a horrible expression, but by the fact that the authority have said you have to rely, or have given to understand that you have to rely on us because you can't have your own. But in point of fact, what has happened over at least 7 years prior, as Mr. Roll says, is the defendant is providing all of the security. Now,
I mean, the point I'm making is that all these cases like Gorringe and Stoven are quite different factual situations. We haven't been shown any case where one's having to analyse a proximate relation which derives from oral arrangements of the kind you're mentioning, as far as I know. I mean, if I missed something, tell me what it is.
no.
Good. That's a relief.
You've understood the respondent's case perfectly.
Yes, good. Well, thank you very much.
And part of what was going on with the control of the access to the airside comes from the documentation that was being prepared by the authority. You've been taken the AASP and so on. You've been taken to that, but if I can just draw your attention to a few points. It is at the back of bundle 3.2, and it starts at 6:30. This is the Airport Authority Security Programme 2000. Right in the middle of that page, the security programme advocates security measures and procedures, will prevent or reduce acts of unlawful interference with civil aviation and its facilities. The NIA security programme is also designed to ensure a secure environment for aircraft. That's the first bullet point on 6:30. So this is the preamble to the programme, and this is one of the reasons for this programme to be coming into existence. 648, airport security officers, paragraph 3.5, are responsible for securing of all access points to the air operations area, the securing of restricted areas, the conducting of air and landside patrols, (667) and 668 is about the access control and the identification badges, etc., that must be clearly displayed. 670 is emphasising the coverage to access points based upon airline schedules. And then 671 is going into a little more information about the identification badge system. And the purpose, middle of 671, of the Airport Authority's Restricted Areas Identification Badge System is to provide positive identification of persons authorised to be in a restricted area. And the requirements of positive identification need of entry has been established. 1, prevent unauthorised person from gaining access. 2, provide a method of detecting unauthorised persons. 3, to safeguard life, aircraft, vehicles, stores, equipment and property. And then 705, security of aircraft. Well, you've already been taken to this to an extent. Of course, aircraft operators are responsible for the security of their aircraft. Another way of putting security there might be integrity of the aircraft. They can't leave the aircraft wide open and then complain that someone goes inside. And protection on the ground. Aircraft remaining on the airport overnight will either have stairs removed, with that, the stairs of this aircraft can't be removed, or doors locked.
I'm so sorry, which page are you on?
Both.
Which page?
Patrols by airports.
Which page are you on?
I'm so sorry.
Which page?
705, my lord.
Thank you.
I'm sorry, I have very little directional. Patrols by airport security and the police force ensure the security of the aircraft during those hours. Now, that, in my submission, could not be clearer. Your responsibility, whilst you're flying your plane and during airport hours, are to make sure that your aircraft is secure. Overnight, you remove the stairs, brackets if you can, you lock the doors, and then we, the airport security, along with the police, will patrol to ensure the security overnight. And that is entirely consistent with the approach that is taken by the authority employees. Mr. Ferguson is asked specifically about this. Page 984 of the transcript. Question, line 9, when one secures the aircraft and leaves the airport at night, the burden then rests on the airport security to keep a surveillance of the area. Yes, we perform the security of the area.
Which witness is this, please?
That was 984, my lord, lines 9 to 12.
Yeah, and which witness is it? Which witness?
Mr. Ferguson, Osborne Ferguson.
Yes, thank you very much.
He's general manager.
Yes.
And it goes further than that as well. It goes beyond the people that are there in the managerial system to the people that are on the ground. And Miss Wynda Sears, who is one of the security guards, she is being asked about the responsibilities that she sees on herself. And she, at the bottom of 914, had you on any other occasion come in and met the planes with stairs down or doors open? Answer over the page, well, we have had that a few times on other occasions. Have you come in and inspected and found that? Yeah, that happened in the past. And you would just report it. If we can, we try and secure it. But if we can't get it secured, we try and contact the operators of the aircraft. So the security guards who are controlling access, their first response, if they see an unsecured aircraft, is not to contact the operators and say, well, this is your responsibility, security. It's to try and secure it themselves. That's all part of their responsibility. Mr. Blatch, who was the other security guard who was called by the airport, said something very similar. 931, line 5, in your opinion and only your opinion, would you, says 8, but I think probably state, that the planes were secured for the night? And his answer is that would be hard for me to say the planes were secured, that's the duty of the ramp patrol. So ramp patrol, also under the airport authority, is, as far as the other security guard is concerned, responsible for the security of the aircraft. So although the airport's stance now is, well, indeed at trial, well, this is entirely up to you operators, you're the ones that have to keep your planes safe. That was not in my submission the view of either its employees on the ground or of the management, or indeed of those who have drafted the security protocols. And of course, you've already seen the bit to which I've taken you to, that it's the authority that takes on itself the responsibility for providing extra security if a threat has been brought to its attention. And that was the reference at page 705.
Well, no doubt you're coming on to this quite soon, but I mean, if you are right to say that there are all these duties on the defendant, then obviously you will be moving on to whether there was lack of due care in relation to them.
Right, the next line, yes.
That will bring us to raise
yes,
it.
Yes, it is, yes. So the question then would be, is the duty of care excluded by the statute? And obviously it was open to the appellant below, at either stage, to say that its statutory role excluded any duty of care, notwithstanding what happened in practice, and say, well, look at the Act, look at the regulations that set us up. This is how our duty of care is limited. It's not just a normal common law care, it's restricted in some way. And of course it didn't do so. And in my submission, this court is not the best placed for attempting to weigh up the sort of public policy issues that might affect whether there was anything in the setup of this specific Act, and would limit what would otherwise be the duty of care on the authority given the circumstances. So to the extent that one needs to look at the statute, and in my submission one doesn't, you have been taken to the bits by my own friend, and what I would say is that there is nothing that expressly or indeed impliedly excludes responsibility for safeguarding the integrity of the airside area where aircraft are left overnight, particularly, of course, when their own documents provide for protection of the airside without reservation, and their own personnel think that's part of the role. So once your lordships and your ladyship are satisfied, as in my submission you must be, that there can be a private law cause of action, then it's quite clear in my submission on the authorities that the test for the existence and, of course, the scope of that duty of care is the Capiro test. The references, and I don't think I need to take you through them, but simply for your references, Stovin at 1342, Everett and Camojo at 1206, Mitchell at 1259, and Rice at 1635. So the trial judge was, in my submission, entirely right when he was focusing on the questions of whether there was a duty of care and what the scope of it was in addressing himself to the Capiro test. Harm to the respondent was a reasonably foreseeable consequence of what the appellant did or failed to do. Where there's a relationship was one of sufficient proximity and in all the circumstances fair, just and reasonable to impose the duty of care on them. Proximity, shorthand, the relationship which makes it fair and reasonable for the authority to owe a duty of care. That's Stavin at 1342, Lord Nichols. I don't understand from the interjections from my Lords Lord Carnwath and Lord Kerr that perhaps I need to address you specifically on the point of proximity, given the points that have already been raised. But on the basis of the relationship such as it was evidenced, what one is looking for is some particular reason, and that's the wording that is used by Baroness Hale and Mitchell at 1277, some particular reason why the appellant should be held to have assumed responsibility of protecting the respondent from the harm caused by an unknown thief. And here, it is the relationship between the appellant and the restricted area where the risk arose. It's not over the thief, and it's not even over the plane. It's the control of the restricted area. That's the important bit. Particularly, of course, in the middle of the night, when there are no scheduled flights and the airport is closed, because anybody that is trying to access the airside at that point, unless they are, according to Ms. Winders-Sears, Bahamas Air mechanics, is not going to be authorised because they are not going to have a legitimate purpose to be there. Part of the purpose of this controlling of access only to the bits where you need to be at the times that you need to be there is to safeguard aircraft. It's set out in the programmes. And this is most akin, in my submission, to the situation in Stansby and Treymans, which is in the authorities bundle at tab 24. Slightly different case in as much as the decorator who left the front door unlocked was under a contract to the homeowner. Not completely different, because of course there was a contract here. But the point that was made, perhaps interestingly in Smith and Littlewoods by Lord Mackay, was that as far as he could see, then the duty of care wouldn't just have extended to the homeowner who had entered into the contract with the decorator. It would also have extended to the guest of the homeowner whose property was also stolen. So no need for there to be a contract in order for there to be some form of responsibility to make sure that the bad guys don't come in and do what you're meant to be protecting them from doing. And that feeds in my submission in this case to the expression that I used earlier for the authority. They were the gatekeepers. They were the ones who, by having the responsibility for guarding the entrance to the restricted airside, they had the responsibility effectively of locking the door to make sure that the only people that get into the house, that get into the airside, are the people that are allowed to be there. So in those circumstances, the trial judge in my submission, of course the Court of appeal upholding him were entirely entitled, and we say right, to hold that there was a duty of care, but only going as far as the scope that was accepted by the trial judge. It's not a sort of duty of care to protect against absolutely everything. I think the point was made earlier about somebody coming in and putting a knife into one of the tyres of the aircraft, although in fact I'm not sure why there should be a conceptual difference there. But the scope that was accepted by the trial judge was not to cause or contribute to the theft of the aircraft by unknown or unauthorised persons. And that's actually quite a restrained scope, which links in entirely with what the responsibilities on the authority are, which is making sure that the only people who are airside in the middle of the night are the people that have got a good reason to be there. My learned friend put in written case and then made the point again this morning, going to this question of the scope of the duty of care, that this is an omissions case, and that therefore it's that much harder to establish a responsibility on whether it's a private person or whether it's a statutory authority. My submission makes very little difference in the context of this case. But so again, we simply don't accept that. This is not an omissions case. It might have been an omissions case if the arguments that were being made by the respondent had been to the extent that what the authority ought to have been providing was a guard at the bottom of every single ramp. So anyone that was coming through the access, they had to walk past a guard in order to get onto the apron. Effectively, we were saying there was something extra that you ought to have been providing. That was not, this is not that case. All that they are being held to, in effect, is that which you said you would do, you had to do.
Well, if it's not an omission case,
Sorry,
if it is not an omissions case,
no.
do you say that there was a positive act on the part of the appellants which distinguishes it from the omissions jurisprudence, if I can put it that way?
Well, because of the trial judge's reliance on res ipsa, one didn't really get into what it was that had been done wrong, save that the theft occurred because someone unknown and unauthorised was able to access the apron. And we know that that is the case because the only people that were authorised to be there were the Bahamas Air Mechanics.
Quite, but I mean, the appellant argues before the board that this was an omissions case. You challenge that argument.
Yes.
And therefore it seems to me that you'll want to try to persuade us what species of positive act was involved, because the appellant, I think, would, his riposte would be surely, well, at its height, the respondent's case was that the appellant was the authority responsible as the gatekeeper, as you have put it, and at the height of the respondent's case, you omitted to enforce the system that you'd put in place. So it is an omissions case,
Well,
I hesitate to say.
there is a useful consideration at the back of Mitchell by Baroness Hale when she is, I think this is in the first volume of authorities. Yes, it is. It's at tab 10. And she's adopting the views of Lord Roger about what counts as being omissions, which is you didn't. It's the Good Samaritan argument, or the way that it was put by Lord Hoffman in one of the cases, I think, was the why pick on me argument, that you didn't have an obligation to do anything, and what's being said is that you ought to have done something. That's what's meant. In my understanding, is a pure omissions case. Now, that is not the question here.
Sorry, where are we looking at in Mitchell?
Sorry, I hadn't got onto it. I was making general comments, my lord. What Baroness Hale was saying, this is 1277.
1277.
Yes, just above G. when she's simply saying, I share the view of Lord Roger in paragraph 55 that it's not a pure omission case. A driver who takes to the roads and is thus an actor in the drama is liable for the things that he fails to do as well as for the things that he does. His failure to keep a proper lookout to indicate what he proposes to change direction is an omission, but he took the action of propelling his car in a particular way. Thus, it could be said that the local authority were actors in this drama. And what she's picking up on is what was being said by Lord Roger earlier. And she says, paragraph 55, I'm not sure it necessarily is. Yes, paragraph 55, which is at page 1270, fourth line down. On behalf of the local authority, Mr. Smith argued that the pursuers were seeking to make the local authority liable for omission for failing to warn. Of course that's right, but the position of the local authority is not exactly comparable to, say, someone watching and doing nothing as a child drowns in a shallow pool or a blind man walks into the path of an oncoming car. That's an omissions argument. You weren't doing anything and you should have done. What this case is about is you were doing something. You had engaged in providing a security control mechanism system, but you did it wrongly. Now, it might have been because you did something actively, or it might have been that you didn't follow through on the procedures that you'd said you would do, but that doesn't make it a pure omissions case. The pure omissions case is the Pharisee walking past on the wrong side of the road when he could have intervened but didn't. Pharisee, Samaritan? One of them. But that's why I say, my lord, that no, we don't accept that this is an omissions case, and the mere fact that you frame your argument as a failed to do something doesn't make it an omissions case, unless what you're saying is, well, you didn't have any obligation to do it, but we say you ought to have done it anyway, which is the Stoven and Wise scenario. So the scope of the duty of care is also, of course, confined to what is fair, just and reasonable. And it's at page 72 that the trial judge sets out what he says the scope is, not to cause or contribute to the theft of the aircraft by unknown or unauthorised person. Now, it's not, it doesn't give the respondent a guarantee against theft. It's not, that scope is not putting the airport authority in the position of an insurer. If someone goes through access control and is logged as permitted to be on apron 5 at 1 o'clock in the morning, there and then gets into the aircraft and flies away with it, then I would entirely accept it would be most unlikely that I would be able to succeed, either in establishing duty of care or indeed on breach. But the scope, as was accepted by the trial judge, was focused on what the appellant could control, and of course said it did control, which was ensuring that access to the airside was only going to be by people who were known, in the sense of them knowing that they were there, and authorised in the sense of the authority and via their security guards having been able to check that there was a legitimate reason for that person to be in that place at that time. So the scope of it, which is entirely, in my submission, reinforced by the evidence that the witnesses were giving about what they had to do to check people that came through their gates, was entirely fair, just and reasonable, because all that the airport authority is being held to is that which it says that it does anyway. Ultimately, it's a question about control of who gets onto the apron. That's all the security that there was, because of the type of plane that this was. If you knew how to open a door by twisting the handle and you knew how to set a plane off, then anyone was going to be able to get it. Now, and this, of course, is set against the background that what we know is that whoever it was who did get into the plane was not someone who was authorised to be there, because the evidence from the authority was the only people who were Bahamas mechanics who were never in the frame at all. Now, turning quickly to this question of res ipsa loquitur, I mean, this is a point that my Lord Wilson and Lord Carnwath wish me to come back to. I mean, this is, of course, it's only a maxim. I haven't been able to find any indication that it was raised before it ended up in closing submissions. But
Thank
of
you.
course, the closing submissions were on the basis of the evidence as it had come out, rather than in pleading form beforehand, how one anticipated that it might. And the trial judge was referred in the closing submissions not only to the authority that set the hair running, Scott, but also to the full test. So he would have had in his mind the three different elements, and that's set out at 145 is where one can see it in the closing submissions. Bit of Clark and Lindsell.
Can we, at your convenience, could we look and see how the Court of Appeal dealt with it at paragraph 35?
Briefly.
Well, that's very kind of you, Mr. Steele.
I'm not trying to uphold the judgment as being...
It's 97.
I'd like to look at 36 as well. At page 97 of the bundle.
They start
they
their
didn't do it, of
consideration,
course.
don't they, above 33.
Yeah.
And they quote a bit of Clark and Lindsell. We'll have to work out whether it's the relevant bit. At 33, they quote the judge at 34. And then 35, in Scott, Chief Justice Earle explained, the doctrine would come into focus when, one, the occurrence is such it wouldn't have happened without negligence, and two, the thing that inflicted the damage was under the sole management of the defendant. Provided those two conditions are satisfied, then on a balance of probability, defendant must have been negligent. And then here's a comment from the Court of Appeal, notwithstanding the submission of counsel for the appellant, there was ample evidence for the judge to find that the doctrine applied. Is there a problem about that paragraph, Miss Deal?
In an ideal world, then it would have been preferable. Of course, that is pretty much exactly what Scott says. In an ideal world, given that now it's understood, as is set out in Clark and Lindsell, that there are the three elements to it.
Well, quite. Could we look then at Clark and Lindsell, which we've got in Authorities,
Yes.
Volume 1 of 3, and could we go to 1095.6, if that's convenient to you?
Yes, that's exactly what I'm looking at, my lord.
And right at the bottom, 1095.6, res ipsa loquitur stems from the judgment of the Chief Justice. Number 1, well, we've read that.
Yep.
Number 2. And then, is there a problem for you in this? Quote, there is, however, a further negative condition. 3. There must be no evidence, Miss Deal, as to why or how the occurrence took place. Now, did the Court of Appeal address the third condition?
Not to the extent that one would have liked.
To some extent they did. Where?
The furthest that I can't go beyond what's written in the judgment.
Then I think your answer is they did not address the third condition.
They've said is and in fact I think in paragraph 34, I think the speech marks should have been after presumption rather than, I think with that finding we entirely agree is actually the Court of Appeal statement rather than being part and parcel of what the trial judge has said. But no, they didn't address the question of whether there is no evidence as to why or how the occurrence took place.
Well, if they had, would they then have reached for the evidence which did not amount to a balance of probabilities conclusion about this errant pilot having stolen the plane?
If they had set out not the bit from the Clark and Lindsell 17th edition that they had, but the bit from Clark and Lindsell 22nd edition that we have, would they effectively have still reached the same conclusion? Well, I say yes, they would have done. This was absolutely prima facie a res ipsa case. And it was prima facie a res ipsa case because of the findings of fact that the trial judge had reached, that the person who stole the plane was unknown or unauthorised, because what we know, if the Court of Appeal had been taken to every single bit of useful evidence, if you like, what we know is that the thief, who was unknown in the sense that no one was able to say who he was not authorised to be on Apron 5 at 1 o'clock in the morning. That is...
Mr. Terreros, he was a pilot. He could have flown this plane.
He'd
had a row with your...
He could have flown the plane. He was not authorised to be in the restricted
No, he
airside
wasn't.
zone.
No, but forgive me. He was one of your pilots. He'd had a disagreement with your company. He was booked on a flight to Cuba that night, but never went. In those circumstances, and he never thereafter returned to work. No evidence as to why or how this occurrence took place, Miss Deal?
No evidence as to how someone who was unknown and unauthorised, which was the finding of fact, reached the restricted airside zone at 1 o'clock in the morning in order to pinch the plane. There was no evidence that might have said, if the authority had nailed their colours to the mast and said expressly before the trial judge, come on, this was Mr. Terreros, wasn't it? I mean, they've kind of flirted with it in the questions to a lot of the witnesses. Well, you know, there were some suspicions. Yes, we know there were some suspicions. They actually said, this was Mr. Terreros, wasn't it? They would not have achieved the conclusion from the trial judge that, yes, it was Mr. Terreros. But what, in fact, they did was they went in and they said, absolutely bald and bold, the thief was unknown. So, against that, how? It's obviously asking somewhat rhetorically, but how would it have been appropriate, either for the trial judge or indeed the Court of Appeal, to have said, well, your whole case is based on the thief being unknown, but nonetheless, we think it's appropriate to say, well, there's some evidence that it might have been Mr. Terreros. That would have been flying completely in the face of the decisions that the airport authority had made as to how they wanted to run their case. And that wouldn't have been appropriate. And so that is why, in my submission, that finding really does, I started with it, it's why it underlines the difficulty, we say, that the authority has. It doesn't matter that we're all doing it now and looking at it slightly differently. We might be looking at and arguing it and making different points. The authority ran a case on the basis that the thief was unknown.
But
And
the process of
accepted
the process of fact-finding cannot be confined by the manner in which the parties present the case. I mean, if there was evidence before the trial judge on which suggested that Mr. Terreros had been responsible, could he have ignored that simply because the authority didn't run that case?
Well, it would have been extraordinarily difficult, and I think I said earlier on in my submissions it would have been perverse had he made that positive finding, when such evidence as there was nobody was captured on CCTV. Nobody logged Mr. Terreros coming into the airport at any point. He hadn't been authorised to be on the airport for 4 days. If he was, even with his pilot's badge, if he's wandering around the apron, that's precisely the kind of scenario when, according to the AASP, the authorities' own guards and ramp patrol ought to have been picking up on this, because you don't have free rein just to wander around because you have a badge.
Well, I quite understand your submission that it would have been perverse of the trial judge to find that Mr. Terreros was the miscreant. But that's quite a different proposition from saying that the trial judge was entitled to ignore the evidence about Mr. Terreros, as my Lord has summarised it, that he was able to fly the plane, he was familiar with it, he was supposed to be going to Cuba, he didn't go on that flight, he never returned to employment, has not been heard nor seen of since. So, again, I ask the question, was the judge entitled simply to ignore that evidence?
He was entitled, to an extent, to take the authority on their case that they were entirely happy to put forward that the thief was unknown. They weren't able, and say that he would not have been able to say, he wouldn't have been able to say, as far as the respondent was concerned, as far as Western Air was concerned, everybody has proceeded before me on the basis that this thief was unknown, but nonetheless, I'm going to make a positive finding that it was one of your employees. No, absolutely.
No. I think I was careful to say...
Well, no, but it does come to the same point, my lord, to the extent about, well, was he entitled to bear it in mind? Well, really, to what end?
Well, if he addressed the three questions that are set out in Clark and Vincel, and he came to the third question and asked himself, was there any evidence as to why or how the occurrence took place? Was he not then bound to at least advert to Mr. Carreras?
Not bound to. Ought he to have done? Benefit of hindsight 8 years down the line.
Ms. Gill, have you forgotten the effect of the concession which you kindly made 10 minutes ago, namely that the whole principle of res ipsa loquitur was only raised in your final submissions after the hearing?
No.
So to say, well, during the hearing it was always accepted that the thief was entirely unknown, really doesn't bite on a problem when you only raise it, or your predecessor only raises it, in final submissions which come later than the other side's final submissions, and which bring for the first time into focus the relevance of the third Clark and Linsell requirement. Do you follow me?
I do, my lord. I'm struggling to see how this would work, that the airport authority has put in written submissions which say expressly on several occasions the thief was unknown. The Western Air cannot resile from them saying that the thief was unknown. This is an agreed fact between us that the thief was unknown. They then see that Western Air have put in written submissions that say, well, res ipsa loquitur. How could they plausibly at that stage have gone back with further submissions? Of course they could have put in a rebuttal, but gone back with something else that says, well, I know we said that he was unknown. I know we agreed that it was a fact that everyone was in agreement on, but actually what you now have to do is you have to consider whether he was completely unknown or only slightly unknown. And that really, that is a difficulty.
Is one of the things you're saying that the judge would have been improperly stepping into the arena if he had found that the third condition had been fulfilled, because no one had ever made the point to him?
Nobody had ever engaged with the realities, I suppose, of, well, if this wasn't an unknown thief, then he might it have been. And if at that point the judge had said, well, and you said he was properly directed, I mean, the submissions do set out the stages, probably, well, there's no evidence as to how or why the occurrence took place. I am faced with both parties putting in written submissions agreeing that the thief is unknown, but nonetheless, I have to consider whether the thief might have been known and whether that thief might have been someone who was really under the control of Western Air, even though, of course, the scope of what he was looking at was not just whether the thief was unknown, but whether he was unauthorised. And we know that Mr. Terreros was unauthorised to be there. The only people that were authorised to be there were Bahamas Air. Western Air knew that, and the authority knew that. So even if one could sort of get around the unknown point, in my submission one can't, there still wouldn't have been any getting around the fact that Mr. Terreros was unauthorised.
I think we've probably taken that as far as we can.
I'm not sure I can take it much further, my lord. I mean, the way that it was dealt with by the trial judges as it is, and indeed the Court of Appeal. But if one does play through the way that the evidence was coming out and the case that the respective parties were pushing forward, then whatever one's suspicions might have been of Mr. Terreros, he shouldn't have been there. And he shouldn't have been able to get to the restricted airside part of the airport that was entirely and exclusively under the control of the authority. That, in my submission, is what the case came to.
So, in effect, there was a very good reason why they shouldn't say it was Mr. Terreros.
I'm sorry?
On that basis, I'm sorry, they would have been making a conscious decision not to say it was Mr. Terreros, because that would have been a concession by them that an unauthorised person had been given authority to be in the wrong place.
From the point of view of the authority, absolutely.
So it was a strategic decision.
It was clearly a strategic decision. They felt that it was preferable to them to say that it was unknown because they thought that the respondent had to prove that they, the authority, had control over the thief. Yeah. Now, they were wrong about that, but it was clearly a strategic decision.
Wow.
Yeah, could you just, sorry, before we leave that point, help me, as a matter of fact, in the Court of Appeal, this issue is dealt with at great length in the submissions of the appellant at page 219 of Bundle 1, and clearly was put forward, and there's mention of Mr. Terreros and the evidence. It goes on and on and on. Do we have anywhere the response to that? I couldn't find anywhere where it was being dealt with by the respondent.
No, this is something of a scattergun approach, that because the Ms. Just Adley had...
I wasn't asking you to comment on it. I was simply asking to say, is there somewhere where we find in the court, because I mean this was raised very clearly, apparently, in the submission before the Court of Appeal. The Court of Appeal deal with it very briefly indeed. What I'm trying to say is there anywhere where it's dealt with in submissions of the respondent before the Court of Appeal, or don't we have them?
Of the respondent, no. The way that the respondent submissions address it is reiterating the very limited role that the appeal court has.
Do we have those?
Yes, we do. They're set out. They start at 259.
I see.
Ground 4, paragraph 15, which starts at 263, is where the res ipsa point is dealt with.
Thank you, that's very helpful.
Yeah.
Right?
And
they cite the Scott case, as indeed does the appellant, yes?
Yeah.
Thank you.
Again, I mean, it's fairly minimalist, but it's reiterating what the test is, and it's reiterating that there was evidence before the trial judge, and that had been considered by the trial judge, and had decided it didn't rebut the inference of negligence. So the emphasis was very much before the Court of Appeal on the appellant not being able to overturn the various findings.
Yeah, I mean, I can read what it says. I just wanted to be pointed to the reference.
Oh,
Thank you.
Yes.
And it is important that the Court of Appeal goes on to say in 36 of their judgment, at page 97, that the judge had approached the case in a logical and fair-minded manner, and that his decision that the appellant was negligent was fair, just, and reasonable.
Well, that's back to duty of care, isn't it?
I think the final sentence, the point I was trying to imply, was
merging of the...
yes, went a bit further than that, because they add on to that a conclusion related to the decision on negligence, on breach.
But fair, just and reasonable would be a set of rather unhelpful adjectives that are said to help in identification of duty. They don't go to breach, do they, Ms. Steele? Yes, very well.
I don't wish to, particularly at 3:15, just getting into simply repeating myself, but the point in my submission, was the relevant one here, was that no one could, either at first instance or on appeal, fairly have pointed the finger at Mr. Terreros as being the perpetrator. It was nothing more than speculation. it might have been different if the party that was meant to record and log everyone that got our side had been able, on any occasion, to say, well, yes, we checked Mr. Toreros in at Gulf 3. There weren't any logs, there weren't any diaries, there wasn't any explanation for how it was that someone who wasn't authorised to be there might have been there if, of course, it was him. And that was the heart and soul of the case in reality. It was only the airport he could control who got outside, and on this occasion they evidently didn't. Unless I can assist you further.
Thank you very much indeed. I think I'm right in saying that Miss Fry doesn't actually appear with you, is that right?
She's acting as my scribe, my lord.
I see. Well, I don't think scribes have a right of audience, so I won't call upon her. Yes, Mr. Houseman.
My lords, my lady, I will be brief in reply. I was going to address you under 4 headings, so I thought I'd tell you what they are now, and you can hold me to them. The first one is private security. The second heading is unknown thief, which will include some comments on res ipsa loquitur. The third heading is omission versus positive acts. And the fourth heading is special relationship. And you'll appreciate that the third and fourth are both aspects of the duty of care question. First of all, private security. In an attempt by my learned friend, having said it's not appropriate for this committee or this board to delve into underlying evidence and facts, because that's hopeless, there was a very brave attempt by her then to go through transcript evidence of Mr. Ferguson and Mr. Butler and to conduct for the first time in this litigation a textual and contextual dissection of it. I say that's not appropriate and not massively helpful. But can I just take you to Mr. Butler's cross-examination and deal with one point that was made by way of context by my learned friend. You will find that in Record 4, Volume 4, page 1007. And this was the evidence that Mr. Butler, who was the current general manager of the authority at the time he gave the evidence in 2012, gave about what had happened in his experience as former general manager of a different airline. And he gave clear evidence to the trial judge to the effect that in that prior capacity, he, i.e. that airline, had asked this authority to provide private security, and it had been allowed. To that, my learned friend supplied you with some new context, which was, well, that could have been to do with a different airport, she said. That point doesn't work, because if you go to the statute which creates this authority, that is Authorities Bundle 1, so Record Volume 6, it's the statute we looked at this morning, which starts at 1063. The Airport Authority Act, Section 3, which I showed you this morning, headed Establishment of Authority, says, Section 3.1, there is hereby established a body corporate to be known as the Airport Authority, to which shall be transferred an airport, singular, specified in the first schedule. The first schedule you see at page 1075, which lists only one airport, the Linden Pindling International Airport, New Providence. So this authority had jurisdiction for this airport only, and when Mr. Butler gave his evidence to the trial judge that he, as general manager of another airline, had previously asked this authority if they could provide private security at this airport, and that they were allowed to do so, that's what that evidence means. That was my first point of 4. Second heading, unknown thief. And we'll look at res ipsa loquitur in a moment. I was just going to say some comments about Mr. Toreros. You have the agreed statement of facts. It's paragraphs 39, 40 and 41. It was still at the time of trial the evidence of the investigating officer, Sergeant Lewis, under cross-examination that Mr. Toreros remained at that point in time, 5 years after the theft, the suspect. At the risk of an advocate's flourish, I would say the prime suspect, but he was certainly the only suspect. And you have there collected together in the agreed statement of facts the evidence about that. It is said by my learned friend, well, he phrases to the effect of, well, he shouldn't have been there. He was unauthorised, by reference to evidence as to how the system is said to have worked. But we don't know that. We just don't know that. We don't know if it was Mr. Terreras when he went airside. We don't know what he told the relevant person checking his badge. And pause for a moment and apply some common sense. If the premise for this line of inquiry is that Mr. Terreras was the thief, it means he set out to steal the plane. Someone in his position carrying an ID badge who was setting out to steal the plane may well have lied to the person checking his badge as to what he was doing going airside when he was going airside, and we don't know when that was anyway. So you have to be very careful about the supposition, the automatic supposition that he shouldn't have been airside and that he was unauthorised to be airside at the relevant time, because we just don't know.
If the system had operated properly as it should have done, would his presence not have been logged?
Well, there were no logs. The answer to that is if the system was operating perfectly or properly, then yes.
But if it wasn't operating perfectly or properly, it wasn't being carefully operated.
But that wouldn't necessarily be causative negligence, and there were no logs in evidence at trial, as I understand it. And we don't know whether he was logged or not, because the logs weren't there. But that's not necessarily causative, because he could have given a convincing explanation of why he needed to be airside whenever it was he presented himself to the relevant security officer. And as I said, common sense suggests that someone setting out to do something that bad would have told fibs if he needed to in order to achieve his aim. So we just don't know. But what we do know is the evidence that was before the judge at trial about Mr. Terreras. As for res ipsa loquitur itself, and as has been pointed out by the board correctly, that was raised in written closing submissions. It was then raised as a ground of appeal. If I can show you just to see where that was, it was ground 4, grounds to the Court of Appeal. So it's record volume 1, and it's page 116. Challenge, ground 4, was that the learned judge erred in fact, and thereby misdirected himself in relying on res ipsa loquitur. And as we know, the gist or the guts of that challenge were then set out in the appellant's submissions, and that is tab 17. And the board has rightly directed my learned friend to pages 219 to 22. I can't remember where it ends. Call it 221. And the references to Mr. Terreras are paragraphs 101 to 103, and that's on record page 221. And what is said there on behalf of my client when appealing to the Court of Appeal was that there was evidence there that he was the thief. He remained the suspect, as confirmed indeed by Mr. Roll, not just the investigating officer, during the trial. And then in 103, by reference to the Midlands case, there was a possibility of interference from someone by whom the appellant was not responsible. I think that should probably be for whom the appellant was not responsible. And that meant the burden flipped to the respondent, to the party alleging or invoking res ipsa, to show that it was improbable. And the reference to the Midlands case there is to the decision you see cited in paragraph 94, back on page 219. And what I was going to do is to show you where that case gets its treatment in Clark and Lindsay. It was a 1971.
Just before we do that, it's interesting, 111, page 223, there you were referring to Earl in Scott and London St Catherine's Docks, but that's then put in the context of the dicta of Lord Devlin in the JSO Petroleum case.
Yes, in which paragraph, my lord?
Well, this is paragraph 111 at page 223, where there's a reference to LCJ, where Lord Devlin approved the rule as per LCJ, but it's then put in the context of the JSO Petroleum case. When the respondents deal with this, they simply refer to the the dictum of Earl C.J. And the Court of Appeal don't seem to deal with the JSO Petroleum case at all, I think.
They don't, nor do they deal with the Midland case, which is one.
Anyway, sorry, I just wanted...
Yes, point noted, my Lord,
Yeah,
absolutely.
thank you.
I mean, you know my general submission about this Court of Appeal judgment, which is,
No, well, never mind
doesn't
about
deal
that.
with an awful lot it was supposed to deal with, but there we are.
Anyway, the Midlands case you were going to show us in Clark and Linsell.
I was indeed, and as I've shown you back on page 219, it was cited and its significance explained before it was then brought home in the Mr. Terreros context in 103, paragraph 103 on 221. If you go to the Clark and Linsell extracts that we put in, so authorities, I think it's in record 6, tab 3, and mine it's 1096, page 1096. And there we have the heading Sole Management and Control, paragraph 8-197.
What do you say to Miss Steele's point that your client had firmly espoused the case that the thief was unknown, and you really can't be had to say on appeal that it was at least possibly Mr. Terreros?
Well, that requires, in a sense, a detailed reading of the submissions that were made below. My reading of them was to this effect, that when it came to contesting the imposition of a duty of care, the pleaded case, I should say, of an unknown and unidentified thief was assumed and embraced because it went to trying to knock down the duty of care.
Yes.
And the primary significance of that, of course, it was a thief that was unknown to and not within the control of the defendant, because it would have been an easy answer to the other side if it turned out that the thief had been one of our employees, and that feeds into something I was going to come on to in my heading 3, which is the difference between omissions and positive acts, that we didn't steal the plane. So the significance of the unidentified nature, if I can put it like that, or the lack of identification of the thief, is primarily relevant to duty of care. It was said, that is your pleaded case, and with that, you're stuck with that pleaded case to try and show there is a duty of care. But when it came to res ipsa loquitur, raised after trial, as we saw in the written closings, and then accepted by the judge in cursory form, the point was taken by reference to Mr. Terreros. So it's not the case that we maintained an unequivocal position throughout, including in the court.
So you actually did, your predecessor raised that before Mr. Justice Adderley?
No, it wasn't raised before the judge, save through cross-examination, because there was obvious forensic indicators in the cross-examination where Mr. Terreros' name was gone over, and it was established more than once from Mr. Rolly and from Sergeant Lewis that he was still the suspect.
I see.
But no submission was made to the judge because obviously we didn't know about res ipsa loquitur, if I can use the word we. The legal team didn't know about that. It was then raised because the judge accepted it. And just to meet a point that Lady Arden raised by reference to paragraph 36 of the Court of Appeal judgment, it does say negligent there, but there is no separate finding in the first instance judgment of proof of negligence. What was said instead, and only instead, in paragraph 22 of the first instance judgment is that res ipsa loquitur was correctly invoked and is the answer, and it relieved this plaintiff of its burden of proving negligence.
But maybe it was directed to the submissions of paragraphs 116 to 118 at page 226, that there was unfairness.
Unfairness?
In the way that the judge had come to his conclusion.
Yes.
And that's why it was expressed in that way.
Yes, that might well be the context for that line. So,
for our note then, where is the Midland Bank case referred to in Clark and Linsell?
That's what I was about to show you.
Yes.
And that is the sole management and control heading above 897, so 1096.
Yes.
You have paragraph 8-197 of Clark and Linsell, and this is the second positive limb of res ipsa. The first positive limb, as we know, is occurrence couldn't take place without negligence. The second positive limb is you've got to show it was within the sole, the thing that caused it was in the sole management and control of the defendant. And then 5 lines down into that paragraph, but where the product could have been interfered with between the manufacturer and accident, the claimant must establish at least the improbability of such interference having caused the relevant defects. Footnote 940, which you see over on page 1096.2, is Lord Justice Magore's dictum at page 756 in the Lloyd case, the West Midlands case, and that's the one you saw cited in the appellant's written analysis, written submissions. So the The correct case in my submission was cited on behalf of the appellants, but the Court of Appeal didn't look at it, didn't touch it at all, and therefore didn't touch the Toreros evidence as it should have, or as it should have found that the judge should have, and therefore fell into error. That's what I was going to say on unknown thief and res ipsa, save for this, which is that if you find, let's leave alone whether you disturb the findings on duty of care, let's say you find that there is a duty of care, if you then find that the Court of Appeal erred in upholding in the terms that it did or at all the first instance judge's invocation of res ipsa, where do we end up? The answer is we end up in a situation where this plaintiff failed to prove breach at trial. This plaintiff chose to run its case at trial that it couldn't show how the negligence occurred or how the thief got to airside. And this plaintiff was not able to avail itself of the magic wand of res ipsa. It has failed to discharge its burden of proof, and therefore the claim is dismissed. Its appeal is allowed.
Well, I wonder, is it quite as straightforward as that? I mean, on your case, the trial judge didn't address the question of negligence independently of res ipsa. If he was wrong about res ipsa, does it not follow that he should have addressed that question?
Well, the trial was 2012.
Sorry?
The trial was in 2012,
Yes,
now in
right.
2020. Yeah. And the answer is, what else was he asked to do? He wasn't presented with a positive case for discharge of the burden of proof. So he did what he was asked to do, which was invoke res ipsa loquitur. If it turns out 8 years later he shouldn't
The whole cursus of the case didn't really touch on res ipsa loquitur at all, did it? It was only at the heels of the hunt, so to speak, that it was introduced after you'd made your submissions.
Yes, but that's the way they chose to try and discharge their burden of proof. They chose to discharge their burden of proof by flipping it onto the defendant. That's the route they chose. They didn't have a backup plan, and the judge went along with them. And if 8 years later this committee decides, via overturning the Court of Appeal, that the judge was wrong to have done that, although it wouldn't be saying that in terms, it would be dealing with the Court of Appeal's treatment of it, 8 years later, then the answer is the plaintiff, that's the bed the plaintiff made. And that's the basket in which it put its eggs, to mix the metaphors. And there's no backup, I'm afraid. And that's that. And that will have been a risk, no doubt, in its mind or in the mind of its legal team when it took that tactical decision. We've heard plenty about strategic and tactical decisions made on my client's side back in the day, but this is the one that looms large now. And that is the consequence and the only available consequence of you overturning res ipsa. That's 2 of my 4 points. The third point was omissions versus positive acts. And I just start with the pleaded case very quickly, just to remind you what the allegation was against my client. And that is 104, and it's paragraph 10 of the statement of claim, the amended, I think it was, or re-amended statement of claim. And those were the 8 particulars of breach that I showed you this morning. When you read them, or indeed the first word of each of them, you will see they are failing, failing, failing. Paragraph 4 says issuing a permit, but I don't think anybody here is relying on paragraph 4 as causation or causatively probative or operative of this theft. So we've got failing, 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 issuing, allowing, failing, failing. 7 out of 8 are omissions, only some of which mattered come trial and today. So that tells you something.
Well, allowing might or might not be an omission, mightn't it? You might allow by doing something positive, like saying, yes, you can go in. Or you might allow by an omission to say, no, you can't go in.
Yes, but the point for the distinction between omissions and positive acts, I was only showing you that to remind you of the way the case is put. The key point to have in mind when approaching whether this is a case of omissions is what caused the theft? What was the immediate cause of the loss, I should say? The loss which is sought to be recovered by way of claim for damages. You always have to look at what is the cause of the loss. And as I said before the break, and as I repeat, and it is fundamental here, my client didn't steal this plane. Nobody on behalf of my client stole this plane. Nobody for whom my client is legally responsible stole this claim. And it follows from that premise that uncontroversial premise that this is a case of omission. Can I just show you a couple of bits in the case law that deal with the distinction? Stoven and Wise, which you have in tab 13 of record 7. It's page, bear with me, it's 945 of the law report, and it's 1353 in the bundle. And it's Lord Hoffman's speech in Stoven, and I would invite you just to look at C to just above E. Because he starts by acknowledging something which has been acknowledged in the course of today's debate, which is, of course, he says, it is true that the conditions necessary to bring about an event always consist of a combination of acts and omissions. And that is echoing, in a sense, what Lady Hale had to say in the Mitchell case that my learned friend took you to. He says, but this does not mean that the distinction between the acts and omissions is meaningless or illogical. He says,
Sorry, where are you?
We're on page 1353, if I've manually numbered my version of Stoven.
Oh, I'm sorry,
correctly.
I thought you were 1354.
Yeah. Is that page 945 of the
No, it's
law report?
943.
Then I have negligently, manually
You want
paginated.
945?
Yes.
That's 1355.
I'm
Right.
grateful to that, and I apologise for the confusion. So it's 945 of the law report, C to D, where he says, of course, it's true that conditions necessary to bring about an event always consist of a combination of acts and omissions. And if you read it down to just above E, the crucial words in my submission are the sentence that says, to hold the defendant liable for an act rather than an omission, it is therefore necessary to be able to say, according to common sense principles of causation, that the damage was caused by something which the defendant did. So you have to look at the damage, which obviously is the essence and the springwell of any negligence claim. You have to look at what caused the damage, and if the defendant didn't himself or itself cause the damage, then you are into the realms of omissions. And that has significance because of the established body of case law, which I see reflected in that, the head notes that my lords and my lady have provided us with in the Poole case. You see the established body of case law from the law of liability for omissions, where you have to bring yourself within one of the recognised exceptions. Was there a special relationship? Was there a specific voluntary assumption of responsibility? Did the defendant create the danger? Did the defendant control the criminal who caused the loss? You have to bring yourself within one of those. If you go then, please, if I could invite the board to have a quick look at the Mitchell case. We went to it for Lady Hale's judgment or speech. I just wanted to show you Lord Brown's. The Mitchell case is in record 6, 10. And I wanted to show you Lord Brown's speech in, picking it up please, at paragraph 82, so it's page 1279, actually paragraph 81. And the cross-reference to Clark and Lindsell, because I showed you this morning, is Clark and Lindsell paragraph 14-62, and it's bundle page 11031. And what Lord Brown says, he starts in paragraph 81, he says, generally speaking, people are not liable for the crimes of others. A is not ordinarily liable to victim B for injuries or damage deliberately inflicted by third party C. And then what he does in the remainder of that page is he deals with recognised circumstances where that can happen, as summarised in the Clark and Lindsell section I showed you earlier. The first of those he deals with is in 82, or rather he's in paragraph 81 with an example of vicarious liable in the landlord and tenant scenario for antisocial behaviour. He deals in 82 with a more general one where A may also be liable for C's crime where he is under an obligation to supervise C and fails to do so. That's often packaged up as the control, where the defendant controls the third party line of cases exemplified by Dorset Yacht. The next one is 6 lines down, 6 lines into paragraph 82. Similarly, if A specifically creates a risk of injury by, for example, arming C with a weapon, that's the recognised exception of where the defendant has created the danger. And just to pick up on the example that was put to me this morning by, I think, Lord Carmouth, what if my client had created a hole, a gaping hole in the perimeter fence? Let's say there was maintenance going on one afternoon on the perimeter fence, and a section of wire had been cropped out, and the standard protocol was to cover it up and secure it for the night, but they just forgot. They didn't do it. Would this case, and let's say thieves got in and they slashed the tyres, or they blew up a plane, or they stole a plane, we don't know. Damage caused, someone unhappy. Would that be a case of omission? Yes, it would, because my client did not damage the plane or steal the plane.
It would be a case of liability.
Well, my lord, if I may, what it would be a clear case of this exception to non-liability for omissions, because that would be a clear case where my client had created the danger. It had left a gaping hole in the perimeter fence.
But why is that different to allowing an unauthorised person through?
Well, we don't know whether someone was unauthorised to come through, so it's not on four with the gaping
We know
hole.
it wasn't a Bahamas Air mechanic, and we know that only a Bahamas Air mechanic could have been authorised.
It's not creating a danger.
I don't think so.
No, in my submission it is not. If a pilot, and we don't know the circumstances of this, but if it was Mr. Terreras and he presented himself in the evening, or whenever it may have been, with his badge, and smiled and told a story about why he just needed to go airside and he went through, then he went through, and that wouldn't be negligence. But that is not creating a danger. It's not the same as the example given here of arming the third party, giving C a weapon. These exceptions to the law's stance against the common law liability for omissions are recognised pockets, if I can put it like that, or categories of exception. The first one was control of the third party. The second one is the creation of the danger. The third one is assumption of a specific risk. We see that after the reference to Attorney General of BVI. Similarly, A may be liable if he assumes specific responsibility for B's safety but carelessly then fails to protect B. And that, of course, is echoed in the Clark and Dinsel passages that I gave you earlier. Specific assumption of responsibility. Which brings me on to the final topic.
Can I just take you back to 1355, which is Lord Hoffman in Stovin, that passage you cited?
Yes.
Between C and E. He says, one must have regard to the purpose of the distinction as it's used in the law of negligence, which is to distinguish between regulating the way in which an activity may be conducted and imposing a duty to act on a person who's not carrying on any relevant activity. One way of looking at that is that you're not in omission territory if someone is carrying on a security activity and the breach of duty consists in failing to carry it on with sufficient care. I'm thinking also of Lord Hoffman's analysis between the NHS and a private doctor, insofar as the activity which you are carrying on is imposed on you by statute.
But what he's talking about, any relevant activity there, has to be read in what follows.
Yes.
The activity is an activity that causes the relevant activity to be relevant, has to be causative of the relevant loss, of the loss being claimed for. So, let's take an example. Let's say that people employed by my client were repairing the tarmac or using a welding device close to an airplane. It flares up, the airplane blows up. The relevant activity there is an activity, and that's an activity that causes. You have to look at the activity that's causative, or causatively, the causative mechanism for the loss. It's not the same as saying, were we conducting some, because in all of these cases of omission, it could be said, if you extrapolate it far enough out, that the defendant is conducting a relevant activity. He's been sued, or it has been sued at the end of the day. So somebody has come along and constructed a case to say, well, you had a responsibility, whether it's the gatekeeper or an analogy to the gatekeeper. You let someone in and then they did it. That's a given, and it's trite. You have to look to see, as Lord Hoffman says in the lines that follow, was it something that the defendant did that caused the loss? It cannot be said that what my client did, even taking my learned friend's case as it's now presented, that my client, at a time unknown, let the thief through the gate when it shouldn't have. Did that cause the loss? No, it didn't. The loss was caused in a very real sense by the act of theft of that independent third party, by a criminal. It's what Lord Brown says in paragraph 81 of Mitchell. The law does not ordinarily find people liable for the crimes of others. Different if he was one of ours and it was an inside job, but it wasn't. It was the crime of an independent third party. And then finally, special relationships. It is the case now advanced by the respondent in an attempt to hold on to this judgment below, is a case that bears no resemblance at all at the risk once again of being forensic, bears no resemblance whatsoever to the case advanced at trial, found by the judge, advanced in the Court of Appeal, and found by the Court of Appeal. There isn't a single reference anywhere that I've seen to anything called a relationship. You've only heard about relationship in the last 2 hours and read about it in those 17 pages from my learned friend whenever you got to read those. Relationship is a new thing. The reason we know that is the case, because if you go back to the judgment in Record 1, tab 6, you see in paragraph 23 on page 74, and I took you to this briefly earlier, that after the judge had reached his conclusion on res ipsa loquitur in 22, he then dealt with, arguably out of sequence, but it really doesn't matter for our purposes, he then dealt with a legal submission as to why there shouldn't be a duty of care. He dealt with that in 23 by citing or dealing with a case called Wallace and Moscow's United Construction Company that had been raised by the defendant's counsel, by my client at trial. That was a Court of Appeal case in Bermuda. And what was urged upon the trial judge was, well, you can't find a duty of care here because there's no special relationship, because this is a case of omission, where the causative act was done by an independent operator. I could forget the facts of Wallace, and you need to find a special relationship, and the judge dealt with that. Now, the judge dealt with that and said, as a matter of law, there is no need for a special relationship to find the duty of care, precisely because the case advanced before him by the plaintiff had nothing to do with a relationship.
Where are you quoting from, please?
The whole of paragraph 23 on 74, and it runs over onto 75.
Well, but what about paragraph 7? He applies the three-stage test and says at the bottom of the page, there was a close proximity of the relationship by virtue of the fact that only the defendant could provide the security in issue because the plaintiff wasn't allowed to provide its own private security.
Sorry, he's using relationship there in just an entirely descriptive sense, not in the sense it's being used now. Now you're hearing about, for the first time, a course of dealing that's said to amount to a contract, albeit one that's maybe not legally enforceable and didn't need to be legally enforceable. And it is that which supplies, that relationship lasting 7 years, which supplies the essence, as it were, of this particular duty of care. But it was not said to be a special relationship because resistance was mounted to my client's invocation of the Wallace case, which said that you do need a special relationship to find a duty of care in this kind of case where you've got an independent criminal causing the loss.
Well, does he say in terms in paragraph 23 that there was no special relationship?
No, he doesn't. He rejects an argument on behalf of my client that you need one to exist. And the reason he rejects it is because the plaintiff asked him to reject it and said that that case was distinguishable. And the reason the plaintiff asked him to, who's now the respondent before you, asked the judge to reject that is because they were not running a case of special relationship. They're only running that. Now, I appreciate that linguistically you might be able to shoehorn that in under paragraph 7. There's nothing whatsoever in the Court of Appeal judgment that helps you one way or the other on that, because as I said, they swallowed this whole, as it were. Now, those are my 4 headings. And that is my reply.
Could I ask you 2 questions?
By all means.
What meaning do you attach to the first sentence of paragraph 22 of the judge's judgment on page 74?
That is the judge's finding of satisfaction of the first positive limb of the doctrine of res ipsa loquitur. If I may go on, there is no finding elsewhere in that paragraph of satisfaction of the second positive limb, nor any consideration of whether the third so-called negative limb is invoked there or elsewhere.
Now, the second question is, if the Court of Appeal had agreed with you that the res ipsa loquitur doctrine had not been satisfied, what would the powers of the Court of Appeal of Bahamas been?
That I may take instructions on, if I may, from my junior local procedural
Lord
expertise.
Chair, I would be interested to know the answer to that. Presumably whatever powers it had, we have,
See if I can get the answer now.
or later. Is that all right, Brian?
You say, in answer to my lady, that paragraph 22 of the judge's judgment is a reference to the first of the three criteria for res ipsa loquitur. I thought the first criterion was that this couldn't have happened without negligence on the part of somebody or other.
Yes.
Whereas paragraph 22 is a conclusion that this couldn't have happened without negligence on the part of this defendant.
Well, then maybe it goes broader than I was interpreting.
So
I'd always taken that to be a reference to the first limb.
Well, have you correctly taken it to be a reference to the first limb? Or was there an error on the part of the judge, even in respect of the first limb, let alone the third?
There may well have been, but it wasn't a point I was making.
Well, the other...
If it's there, then it's there to be made. I think what it doesn't show, with the greatest respect, and picking up on something Lady Arden asked earlier of my learned friend, what it doesn't show or doesn't constitute is any independent finding by this judge of the discharge of the burden of proof of negligence. It's not saying that, because it's quite clear that that is part of the following the paragraph about res ipsa loquitur, and that was the only basis on which proof of negligence, if I can put it like that, was advanced by flipping the burden. I've taken quick instructions. The Court of Appeal in 2014, when it heard this case, 2 years after trial, as one of its powers, would have had the power to remit to a different trial judge, because by that stage, Mr. Justice Adderley, as I understand it, had been promoted to the Court of Appeal, not this panel. I think he'd gone up by then. He had already been promoted by then. So they would have had the power in 2014 to do that, to remit the case. But whether they would have exercised that power would have involved some form of consideration of whether that was appropriate or not. You have my submissions now in 2020, putting jurisdictional issues aside, as to whether that would be appropriate. In my submission, it wouldn't be, and it wouldn't have been appropriate for the Court of Appeal to use that particular power of remittance or remission back then, for the simple reason that this plaintiff chose to run its case on proof of breach under res ipsa only, to relinquish itself of the burden, flip the burden onto the defendant, and it got away with it. It won. And if you disagree with the Court of Appeal's upholding of that, and you overturn the Court of Appeal's decision on that basis, then this claim stands dismissed, unless I can assist the panel further.
Thank you very much. Now, Ms. Deal, the written submissions on GN, is that the name of it? Yes. When can you have those in, please?
I'm not sure. I will obviously read it properly, but it doesn't look to me as though it actually contradicts anything that I was saying.
You don't want to make written submissions?
But I will read it more
I was in the
carefully.
case. I don't think it contradicts anything you said at all on that point.
Not more
Well,
quickly.
well-
But the one thing that I would, with respect, like to come back on just shortly is that 145 is where the Western Air was not nailing their colours solely to the mast of res ipsa, that they were setting out a case, albeit in limited fashion, about the negligence of the defendant. So it's not, with respect, correct to say that they were simply saying this was a res ipsa case. But I will of course read the Poole case and put something in writing if needs be.
Well, if you're going to make written submissions, can those be in 1 week?
Yes. I'm sitting next week.
Well, it's not inimical to doing a little work in the evening.
Slightly Mersenne City, not quite illustrious.
Well, shall we say
Could I
10
say
days?
14 days?
Well, all right, 14.
I'm grateful. It may well be that I simply do a sort of effectively nil return, but I will, if I can do it next week, then I will.
Yeah.
But it would be valuable to have the up-to-date references of the consideration of the principles.
Yes.
They are the same.
Yes.
And Mr. Hosman, you will have the same period to make any written submissions you wish.
So I should be standing for parts of next week rather than sitting.
Oh,
Yes.
yeah.
None the worse for that.
Sorry, can I just check? Ours is consequential with the same period, or was ours?
Yes, no, the same period. And I know that Ms. Deal will try to get hers in a week, because we don't want this case to fester.
No.
in our minds.
Longer than it has already.
Right. Well, I'm very grateful to Council for the submissions. The Board will take time to consider what advice they will humbly tender to Her Majesty, and the Court is now adjourned.